Hey, I'm here today to talk to you a little bit about the Supreme Court cases that you need to know for Unit 1. With the new AP curriculum, you are required to know 15 Supreme Court cases, and specifically not just know them, but be able to apply them, be able to discuss them into your FRQs or multiple choice questions where bigger themes might come up. You have to be able to problem solve with them or give them as examples. All of that can be a little bit tricky, but I want to introduce you to these two cases today, and this will probably be the last video on content for this unit before the test. So the two cases are right here. It's McColloch versus Maryland, which is actually a really old case, 1819. And then the other one is U.S. versus Lopez, which is 1995, which is fairly new. The other thing I'd have to say is they're not only different in when they were decided, they have different effects on the scope of government. Another thing I need to tell you is that a lot of times Supreme Court cases end up kind of guiding or leading our country in certain directions. That should make sense because maybe in middle school you learned that the executive enforces the law, the legislative branch makes the law, but the judicial branch interprets the law. And interpreting the law is incredibly powerful because you can, in your interpretation of it, you can shift the power or the distribution of power in our country in this case. So let's get into these two cases. In order to do that, I need to give some background. Again, we had talked yesterday about federalism being this, again, you have these kind of two spheres and some overlap areas here as well. And then I said, in the Constitution, the national power is usually listed. It's enumerated or expressed in the Constitution directly, especially Article 1, Section 8. And there are 18 specific laws or things that Congress has the power to do. Okay? And that's kind of where our story starts. And that is going to be with McColloch versus Maryland. So in McColloch versus Maryland, it's 1819. The federal government is fairly new. The national and state governments are fairly new. And over here we have our Constitution. And as part of that, you start to get this rise of business and commerce and things like that. And what ends up happening is that to stabilize our economy, people want to start a national bank. And the national bank, similar to the Federal Reserve today, has the power to control the economy and maybe print currency and, provide a bank to the banks and some of those things that you may have learned in economics. The problem is that this Constitution over here does not mention anything about a national bank. And yet the people, especially Alexander Hamilton and some others who are very, very industrial in their mindsets and believe in the power of business and so on, really want a national bank to stabilize the business climate. And so they start a national bank, and it is challenged in court, where people say, no, we want to challenge that authority. What the court does decide in this case, and it's groundbreaking in a couple ways. One is it agrees that there can be a national bank, even though it's not mentioned in the Constitution. And what they establish is on the 18th of those 18 powers listed in Article 1, Section 8, the 18th one is that the Congress may make all laws that are necessary and proper for the execution of law in the United States. And that necessary and proper clause, sometimes it's called the elastic clause, it does create this situation where it gives us something called implied powers. Okay. And so, in the case of McColloch versus Maryland, it agreed that, a national bank could be started under the implied powers. Tremendously powerful because in our grand kind of scheme, or grand debate, like over here we have weak national government, over here we have strong national government, it does kind of take, federalism somewhere in the middle, and it seems to shift the power of the federal government more towards strong central government because suddenly the government has these implied powers And it can do things like start national banks, which then help it consolidate some of its power. Okay, and so that is certainly a law that is going to shift our country, or not a law, but a Supreme Court case that is going to shift the power of the federal government over towards stronger central power. Okay, so hopefully that makes sense for you on that case. You can read more about it. The Chief Justice at this time is John Marshall. He's one of the first Chief Justices, an incredibly influential guy in the power of setting up the judicial branch. And everybody would say that. It's not like a political thing to say he was the most important. People, Republicans and Democrats, would say he had an important influence on the development of our judicial branch. Okay, so anyway, hopefully your takeaway is McColloch versus Maryland pushing in this direction. Okay, let's come to our second case then. U.S. versus Lopez, 1995. Here's the backstory on that one. Texas has a law that you can't bring weapons into schools in 1990. But in 1990, the federal government also makes a law called the Gun-Free Schools Act. So that's what happens first. In Texas, there is a guy who ends up taking a weapon to school. He's an 18-year-old. He has a permit, but he takes it in. He is charged with possession of a firearm on a school campus by both the state and the national government. Okay, that, by the way, is called concurrent jurisdiction. However, the feds charge him. The federal government charges him in a federal court, and he says, "Well, wait a minute here. This doesn't seem very fair." Maybe not him, but his lawyers do, and because they see the bigger implications here. Maybe he did as well. But what ends up happening is they take that law to court. They basically say, I'm not sure that law is constitutional. I'm not sure the federal government over here has any power over state schools. And the only reason you would have power over state schools is there's something called the Interstate Commerce Clause. But education isn't interstate commerce. And so the federal government, in the case of the Gun-Free Schools Act of 1990, overstepped its bounds. And it went all the way to the Supreme Court. Supreme Court agreed with Lopez and basically said, yes, the federal government over here has no business making laws about schools, especially schools that don't cross state lines. And therefore, this constitutional or this law is unconstitutional. It should be wiped out of the laws of the United States. Okay. Now, obviously, you can see it has quite the opposite effect. When the Supreme Court decides with Lopez that the Gun-Free School Zone Act is unconstitutional, it basically starts restoring power to state governments. And it is able to kind of push this whole idea of federalism back towards weak central government and give more power to the states. So 2 different Supreme Court cases, you need to know them. But like I said, a lot of times you need to know how to problem solve them. You need to know how to apply them. Both these cases of the 15 directly deal with the whole concept of federalism. They are often used in FRQs as examples. One that, examples of cases that strengthen the federal government, national government. And in this case, one that weakens the federal government. This can go with what I had talked about yesterday with block grants and some of those other, cooperative federalism and so on. So anyway, I am hoping that this solidifies these in your minds. Again, you may want to research them a little bit more, but definitely know what I told you, at least initially in this video. Thanks a lot and have a great day.